गुड इवनिंग फ्रेंड्स। ये बहुत ही बड़ी न्यूज़ निकल के आ रही है कि BSTC B.Ed विवाद में सुप्रीम कोर्ट ने फैसला सुरक्षित रख लिया है। अगले शुक्रवार तक लिखित में आर्गुमेंट रिप्लाई जमा करने का समय दिया गया है। जो भी है इसमें मैंने इसके साथ अटैच की हुई है, ये आज की जो भी हेयरिंग हुई है, आप इसको भी सुन सकते हो। बाकी ये रमेश रुयल जी ने भी अपने चैनल के थ्रू ये बता दिया है कि सुप्रीम कोर्ट में फ़ैसले को सुरक्षित रख लिया गया है और जो भी लॉयर्स हैं उनको आर्गुमेंट रिप्लाई जो भी लिखित में जमा कराने का समय फ्राइडे तक का दिया गया है। तो अब देखते हैं कि फ़ैसला किसके हक़ में आता है। तो ऑल द बेस्ट, चाहे वो B.Ed है चाहे DLED है, जो जेन्युइन है, जिसका हक़ है उसको मिलना चाहिए। ठीक है, ओके, थैंक्स फॉर वॉचिंग। Please like, share and subscribe.
So comes by an amendment in 2015. So may I please read this for my Lord's benefit? And so if you had to exercise, there was, my Lord's, just relax minimum qualifications required for appointment as a teacher for such period not exceeding 5 years as may be specified in the notification, provided that a teacher who at the commencement of this act does not possess minimum qualification as laid down under subsection 1 shall acquire such minimum qualification within a period of 5 years. So the statute itself gives the time of 5 years from the commencement of the act. Now, my Lords, in 2015, this further extension to acquire the qualification was brought in by an amendment. And that period is also over.
This is not applicable in this case.
It's not applicable.
Because this is for in-house teacher, correct?
Yes. Now, my Lords, I
refer to this.
Absolutely. So, my Lords, therefore, my submission is this for my Lord's consideration. 23(2) operates in 1 and 2 operate in two different realms altogether. 23(1) is fixing of an eligibility by an academic authority, no power reserved to the central government. That's my first submission. So far as 23(2) is concerned, certain power has been reserved to the central government to make a change or to relax the minimum qualification, but subject to the preconditions set out therein. It is not the case of the present petitioners before my Lord that the precondition under 23(2) is existing. Neither is it the case written in the letter of MHRD or, for that matter, the letter of the minister.
No, subsection 2
Yes, my Lord.
gives power to the central government
Yes.
to relax those conditions for a period of 5 years old.
Yes, my Lord. Yes, absolutely. I'm going to...
So, after, when was this notified? Let's say 2010.
Yes, my Lord.
So, beyond 2015, is it your case that central government had no power to relax it?
My Lords, they could not have done that because that is over, that period is over. But
Therefore, there is
I was reading that third proviso. Please, that is what I was going to read, my Lords. I said that they have given that further. They have done it by way of a further proviso. Please come to that.
That was the amendment.
Yes, my Lords, please come to provide it further.
No, that is for the teachers who are already there.
Who are in service
Who is
teacher.
appointed.
Yes.
between 10 to 15. Even between 10 to 15, when the Act came in 2009, relaxations were provided and those were continuing till 2015. For them, the last extended period is 4 years.
After that, there is nothing.
Because the relaxations were provided in various states.
Provided further that every teacher appointed or
in position
as on 31st March. This amendment comes into force on 1st of April, a day after. So these teachers, this is for those teachers who are already there.
So for that,
This relaxation for 4 years in 2017 means till 21.
My Lords, this came in 20.
It will extend for 4 years, counting from 17.
My Lords, can my Lords look at the footnote? It is with effect from 1st April 2015.
Then,
So it will, my Lords, get over in 2019.
or 19, whatever it is.
Whatever it be, the period is over today. The issue is that the period is today over in any case.
No, no.
But my Lords put a question to me.
No,
That
it
is it a case that
for future, then it is not over when the notification had come, which is this. In this case, it came in 2018.
Manoj,
If this relaxation is also
Manoj, this is
for fresh recruitment, then it
this
would,
cannot be for the fresh recruitment number one. This is for those people only who are in service. So this does not have any application.
So why are we going time? This doesn't apply.
I am not on that aspect, different part aspect. I am saying that even if central government had to exercise any power, it had to satisfy the first three preconditions. 23 preconditions.
Just state-wise.
Statewide. State should have come. And there we have five.
But they have said state as well, Uttarakhand is correct.
Manoj, then it could be for Uttarakhand.
But they said KBN also,
Manoj,
Kendriya Vidyalaya is everywhere.
Kendriya Vidyalaya, then for Kendriya Vidyalaya, but not for every state. Not for every state. Not an omnibus notification say, they're saying do a bridge course.
Not framed till date.
Which is not being framed, of course, till date. There is no bridge course. It was admitted yesterday. And zone of consideration versus eligibility. Eligibility is in 23(1), prescribed by the academic authority. What is sought to be done under 23(2) today, which is not done under 23(2), but even if I say under 23(1), is an expansion of a zone of consideration, of enhancing the number of eligible persons by treating the B.Ed to be eligible. Manoj, even if something like this had to be done, I asked myself the very first test what it would be. Even if the zone of consideration or the eligibility is to be relaxed, it cannot be done ex post facto to say that you will be eligible, but you can acquire a qualification later on, which qualification till today has not seen the light of the day because there is no bridge course as the day. At best, if there was already a bridge course and a B.Ed candidate had done that particular bridge course and acquired that pedagogical qualification under that bridge course, they could have been eligible and the zone of consideration could have been enlarged. But for it to be put that you are already in the zone of consideration, you participate in the examination and you acquire your qualification later on.
That's it.
That is basically my argument.
Only 5 minutes on this. The Lordship have put us a query that if the NCT, only 5 minutes to add to this. The Lordship have put us a query if the NCT would have done this, then whether it would have been justified. Now, in that sense, we have raised this issue when the writ petition was filed. The NCT notification was challenged and is being dealt with in reference to Article 21A. The right to quality education read with Article 14 and 16 in reference to public employment. Now, the stakeholders involved under the NCT Act is the central government. The states being the representatives, the experts being there. There is a mechanism provided for deliberations and discussions thereafter. So, what I'm submitting is that the child
this going on.
I am item number 28.11 and 28.21.
You are Rajasthan.
No, I am from the candidates who belongs from the Bihar and UP.
The first we had Bengal. Let's have Bengal.
I will be very concise before your lordships in making my submissions because broadly or minorly all of the points are being covered of ours.
What is left?
Now the relevance to your lordships will find while power was exercised by the NCT under section 23 of the RTE Act, they have not taken into consideration.
This is a challenge to a separate interim order after a year. Let's hear it. Your Lordship may conclude Rajasthan and then hear it. Just a minute.
They have not considered.
Rajasthan is concluded.
Interim order has been have followed in Totodar.
But interim order says
it has followed Ram Charan Maurya. It has followed Ram Charan Maurya.
Yes.
Not right. That's another matter. This is 28.13.
So I'm sorry, I missed it up. Ram Charan Maurya has a specific paragraph that notes that there was no challenge to the notification.
Kindly give that in the note.
I will put that down, but I want to point
We know that there is no
There is a specific noting in the judgment that there was no challenge.
Yes. Now, your lordships, if your lordships kindly come to the SLP malot, petition malot 28.13, that one, page 107. What is the situation prevailing in the state of West Bengal? I have malot stated throughout in malot the petition.
Let down.
I'll come to that. She says regulation. I'll come to
Yes.
She says regulation. I'll come to that. I'm conscious of that.
Then 29(1), a pari-material provision has been read in Bombay Port Act, whatever it is.
I'll tell your lordship. I'll tell your lordship what Bombay Port Trust judgment is. Bombay Port Trust had regulations. Those regulations said degree holders are eligible for appointment as assistant engineers. The government wanted to make diploma holders eligible. The government issued a directive under its power to issue directive saying diploma holders are also eligible. That directive was challenged. Paras 16, 17, 23, 24, your lordships hold, and in the face of the regulation, such a directive could not be issued. Please have that judgment immediately, those two paras only. When your lordship sees it at your lordship's leisure, before your lordship finally takes a view, just this is that judgment. If there had been no notification adding B.Ed in the 2010 notification, and the government had issued a directive to NCTE to make B.Ed people eligible, and NCTE had said yes, they are eligible by an executive order without notifying it, then the Port Trust judgment would apply. I hope I am clear in the distinction I am making. There are...
Are you trying to say because in Bombay Trust case there was nothing like 23(1)?
No. In Bombay Trust case, the basic regulation prescribing the qualification had not been amended. Without amending the regulation prescribing the qualification, a directive had been issued to make diploma holder eligible. Under the Bombay judgment, only degree holders were eligible under the statutory regulations for... Just take that judgment for 1 minute. Because we will have to read the judgment.
Page 568 in volume 3 of the compilation.
Just have that judgment.
Yes.
Just have... kindly take up para 5.
Page 571.